Friends, welcome to the 38th session of Legal Empowerment Through Interaction lecture series. We welcome you all to this continuous learning process that we have started a couple of weeks back. Thanks to the lockdown, we have been putting our time to constructive use. We welcome Justice V. Ramkumar sir for your valuable presence today as well, and also the district judges and other judicial officers present. We welcome all of you, all the participants we welcome. Today we have Justice C.T Ravikumar sir. He will be dealing with preventive detention, legality and constitutionality. Though a vast subject, I'm sure that sir will be taking us through the nuances of the subject within the 1 hour and odd time that is our disposal. Sir, over to you, all yours.
Thank you. Good afternoon all.
Good afternoon.
What should my worthy audience? I'm very happy to know that Justice Ramkumar and Justice Nagamatu are here, and I should be very cautious now. The subject, virtually before starting this, I should take this opportunity to congratulate Mr. Shyampadman and his friends for this endeavor. This is nothing but a wonderful venture.
Thank you, sir.
The subject I am to speak, preventive detention. In my estimation, it's very difficult to cover within 1 hour. Still, I will make an earnest effort to make a satisfactory.
Correct.
Audio problem.
It's okay, sir.
Audio.
It's okay.
It's okay. Of all the branches of law, the branch that clearly touches and concerns a man in his day-to-day life is certainly criminal law. Every citizen has the right to be free from fears of harm to the person and property. Hence, naturally, any society will prefer lawfulness to lawlessness. To such a society, both punity laws and preventive detention laws would be momentous. Then the question is, what is preventive detention? We all know what it is. However, one could not find any authoritative definition of the expression preventive detention in Indian laws. This expression had its origin in the language used by the law lords in England while explaining the nature of detention under Regulation 14B of Defences of Realm Act 1914, which was passed on the outbreak of the First World War. But Supreme Court of India explained it simply by stating this, I will quote: the object of detention is not to punish a man for having done something, but to intercept him before he does it, and thus prevent him from doing it. And this, the Apex Court virtually stated so in Paul Manican's case. In short, preventive detention is nothing but jurisdiction of suspicion. Am I audible?
Yes, sir.
Yes.
Very much.
Yes. And one may take it as a paradox that the founding fathers of our constitution, who suffered mostly because of preventive detention laws, gave constitutional sanctity to it, that too in part 3 of the constitution that deals with fundamental rights. I will explain the recent entry for this remark. History of preventive detention predates the Constitution and can be traced back to early days of British rule. To be precise, East India Company Act 1784. And virtually that cannot be said to be strictly said to be a preventive detention law, though it contained provision for preventive detention. And the first preventive detention statute prevailed in India was Bengal Prisoners Regulation 1818. I will repeat, Bengal Prisoners Regulation 1818. That was the first true preventive detention statute. And it remained in force till 1947. And it is happening to note that this was the most effective weapon of the British to quell political violence. That is why I said, even after suffering under this, our founding fathers of the Constitution gives constitutional sanctity to preventive detention, and especially in Part 3. Definitely, my reference is about Article or Clause 3 of Article 22. And before saying anything about Clause 3 of Article 22, definitely one will have to see what is there in Clauses 1 and 2 therein. Virtually twin fundamental rights each are there under Clauses 1 and 2 of Article 22. I will shortly state what it is. Of course, everyone knows that. A person who is arrested, that is, an arrested person is not to be detained in custody without being informed as soon as may be of the grounds of his detention. That is under Article 22(1). And I will ask, now I will request everyone to note that particular words, as soon as may be. So the first one under Article 22(1) is, an arrested person shall not be detained in custody without being informed as soon as may be of the grounds of his arrest. The second fundamental right available under Clause 1 of Article 22 is that such a person shall not be denied the right to consult and to be defended by a legal practitioner of his choice. And coming to Clause 2, such a person is to be produced before the nearest magistrate within a period of 24 hours of his arrest, excluding the time necessary for the journey from the place of detention or the place of arrest, rather, to the magistrate's court. That is available under Article 22(2). The other one, which is also there in Article 22(2), that is Clause 2 of Article 22, is he shall not be detained in custody beyond the set period without the authority of a magistrate. It is after giving these safeguards to an arrested person that Clause 3 was introduced. Clause 3, which virtually permits such detention in accordance with or after due process of law. And before taking that, it is also necessary to see that certain provisions are there in the Code of Criminal Procedure as well. That is analogous provisions to the provision which I referred to here before. That is sections 56 and 303. 56 and also 57. Section 56 and 57 of the Code of Criminal Procedure. Of course, we know that under 56, the person arrested to be taken before a magistrate having jurisdiction in the case. And in section 57, the person arrested not to be detained more than 24 hours. Coming to 303, a right to be defended by a pleader of his choice. And then I will come to this Clause 3 of Article 22. 3, it says, nothing in Clauses 1 and 2 shall apply to a person who for the time being is an enemy alien, or to any person who is arrested or detained under any law providing for preventive detention. Before delving further with the Indian laws, preventive detention laws, I think it is only appropriate to refer to an international instrument on the issue. That is International Covenant on Civil and Political Rights, in short ICCPR. I will repeat. The instrument is International Covenant on Civil and Political Rights, ICCPR. The one which is to be noted there under the article which is to be noted there under is Article 9.1 of ICCPR. I will say what it is. It reads like this: everyone has the right to liberty and security of person. No one shall be subjected to arbitrary arrest or detention. No one shall be deprived of his liberty except on such grounds and in accordance with such procedures as are established by law. So we can see that virtually there is no prohibition even in the international covenant for preventive detention. Therefore, in one sense, we can say that our laws, that is preventive detention law, and which was given sanctity, constitutional sanctity under 22.3, we don't go against or go in conflict with this Article 9 of ICCPR. But at the same time, it is to be noted that in against this Article 9.1 of ICCPR, Government of India entered a reservation. Of course, you know, a reservation to international covenant is a statement by that particular nation. It reveals, virtually it is for the purpose of letting known the other countries, the other nations, what actually is the view of that particular nation which endorses the reservation on that particular article. And we virtually made it clear that our view on preventive detention laws under Article 22 of the Constitution of India do not involve arbitrariness, or rather arbitrary, it is arbitrary or unlawful deprivation of liberty. That was our reservation which we entered against Article 9 of ICCPR. Now, reverting to our detention laws, that is the detention laws in our country, one can see that the subject of preventive detention is mentioned in the Union list, that is Schedule 7, List 1, Entry 9, as well as in concurrent list, Schedule 7, List 3, Entry 3. I will simply read it because under. So the subject of preventive detention mentioned in Union list, that is Schedule 7, List 1, Entry 9, it reads thus: preventive detention for reasons connected with the defense, foreign affairs, or the security of India, persons subjected to such detention. And then coming to concurrent list, it is there in Schedules 7, List 3, Entry 3. Thus, it is clear that the center and the states are free to have their own preventive detention laws. However, the center's scope and width of legislative powers on this subject is larger than that of the states. This is because center can have a preventive detention law for reasons connected with the defense, foreign affairs, and security of India by virtue of Entry 9, List 1, in addition to what is permissible by virtue of Entry 3 of List 3. This is just like an introduction. Now, after the independence, the first preventive law of that kind was virtually introduced by this act, but it is not actually this act, in fact, it is Madras Suppression of a Disturbance Act. That is the first one which was enacted after independence. I'll repeat, it is Madras Suppression of a Disturbance Act 1948. But at the same time, the first preventive detention law passed by the Parliament in 1950 is Preventive Detention Act 1950, and it remained in force till 31/12/1969. Though it remained only up to 31/12/1969, one cannot make any discussion on this subject, preventive detention, without reference to one cause celebre of 1950s. On this subject, that is, of course, all of you know, it is A.K. Gopalan versus State of Madras, a 1950 Supreme Court 27. The constitutional validity of the act was tested before a 7-judge bench of the Apex Court, which ultimately culminated in the landmark judgment in A.K. Gopalan's case. Of course, the act was upheld, but at the same time, two major points in relation to Article 21 were settled thereafter. So, in A.K. Gopalan's case, two major points in relation to Article 21 were settled thereafter. Firstly, Article 19 and 21 and 22 were mutually exclusive and independent of each other, and that Article 19 was not to apply to a law affecting personal liberty to which Article 21 would apply. I think that I should repeat it. So the two major points in relation to Article 21, which were settled in A.K. Gopalan's case, the first one, Article 19 and 21, Articles 21 and 22 were mutually exclusive and independent of each other, and that Article 19 was not to apply to a law affecting personal liberty to which Article 21 would apply. Second one, a law affecting life or personal liberty could not be declared unconstitutional merely because it lacked natural justice or due procedure. So that was the second point, which was setting, which is having bearing with in Article 21. I will repeat that: a law affecting life or personal liberty could not be declared unconstitutional merely because it lacked natural justice or due procedure. The law settled in A.K. Gopalan's case remained, and it governed the field for nearly 3 decades. Article 21, which had lain dormant for nearly 3 decades, was brought back to life by the decision in Maneka Gandhi versus Union of India, 1978 Supreme Court 597. And if we are scanning the decision in Maneka Gandhi, one could say that actually, or rather practically, it overruled Gopalan's case, A.K. Gopalan's case. The expression personal liberty was given an expansive interpretation in Maneka Gandhi's case. It was held that it ought not to be read in a restricted sense so as to exclude those attributes of personal liberty specifically dealt with in Article 19. That is why he said practically it overruled A.K. Gopalan's case. And immediately thereafter, one will have to make a mention about A.K. Roy's case while speaking of preventive detention. A.K. Roy versus Union of India, reported in AR 1982 Supreme Court 710. There virtually the question was, does the word law in Article 21 include an ordinance? Can the ordinance lay down procedure to to deprive a person of his personal liberty. This question, or rather these questions, were raised in the context of a National Security Ordinance 1980. I will repeat once again. The question in A.K. Roy's case was, does the word law in Article 21 include an ordinance? So in this situation, it is this context, it is only apposite to refer to Article 21. Everyone knows it, still I will read it for fitness of things. 21 says protection of life and personal liberty. No person shall be deprived of his life or personal liberty except according to procedure established by law. And in this context, that we should look into the questions which were posed for consideration in A.K. Roy's case. And of course, it was answered that an ordinance is as much law as an act. That was the finding of, or rather the conclusion of the Honorable Apex Court. And with this, I will come to the other provisions. After the incorporation of Article 22(3), I have already said that the first act which was brought in was Preventive Detention Act 1950. And that was there only up to 31/12/1969. And thereafter, now there are so many laws. Central laws, state laws. As central laws are concerned, the main laws of the Conservation of Foreign Exchange and the Prevention of Smuggling Activities Act 1974, as then the National Security Act 1980. No, I am audible.
Oh,
Yes.
no, audible and visible, sir, both.
You are referring
Sorry
to
for
the
the disturbance.
The
statute.
central acts, you are referring to the, like Ramkumar said, you are referring to
National-
other central acts and state enactments.
National
I
security.
just introduced all those things and how these preventive detention laws had its origin, and thereafter, after independence, which are the laws. The first law which was enacted was in 1950, which was not now in force, and it was there up to 31/12/1969. That is the Preventive Detention Act 1950, where under the Apex Court rendered the decision, landmark decision in A.K. Governance case. And I do not want to say much on MISA, the decision thereafter. And now the laws which are now in force, the first one, Central Act, COFEPOSA, passed with the above object of checking smuggling and foreign exchange violation. And then the other one is National Security Act 1980, acronymed as NSA. This was brought with a view to prevent persons from acting in any manner prejudicial to the defense of India and the relations of India with the foreign powers, etc., etc. And then the powers for detention, preventive detention, under these two laws, that is COFEPOSA and NSA, that is there in Section 3. Section 3 of the respective acts confers power to make orders of detention. Under what circumstances and what purposes, and due to paucity of time, I am not reading or taking you through those provisions. But those provisions, the Section 3 of those acts confer that power. And coming to the Kerala Act, which I think that most of the persons who are from other states also must have been aware about it. That is called Kerala Antisocial Activities Prevention Act 2007, commonly called as KAPA. There also this power is there under section 3. So in all these enactments, the power to order preventive detention orders or to issue preventive detention orders are there in section 3. Then the peculiarity of a section, again, is it audible?
Yes, sir. No issues.
No issues. There, the power to orders for detention under KAPA, it is there available there if a person is on objective satisfaction. If it is found that he is a known gunda, that is under section 202 of this act, or a known rowdy under section 2P3 of the said act. So on forming the objective satisfaction regarding the question whether he is a known gunda or a known rowdy, then of course the detaining authority has to form his subjective satisfaction.
Actually, it should have been notorious gunda and notorious rowdy. Known, you only say known singer. He is a known dancer, not a known gunda.
A misnomer. It should not be like this. A person who is a notorious, now he is actually described as a known person, a known gunda, a well-known gunda. But the legislature thought it fit to coin that term. We cannot do anything. That term is there, and it is defined also. Under what circumstances or in what circumstances one can be called as a non-gunda and a non-rowdy. And then the constitutional safeguards, they are there under Article 22(4) to 22(7). They are the safeguards. And the most important among them, definitely, I should say that the right to make a representation. The right to make a representation immediately after the arrest and detention, that is available under 22(5). Then the question whether it is only a right to make, merely to make a representation, or whether it actually enjoined a corresponding duty on the authority, the detaining authority, to consider it by applying his mind. That was also considered by the Apex Court. And virtually it was felt that not only the right to make a representation, it also requires the detaining authority to consider the same by applying mind. That was also held by the Apex Court. The another point, in certain, while sitting in on bench, we have many times find non-mentioning of the period of detention in the order. Then the question is, what is the impact? Whether
that should not be, is it not?
Pardon?
The detaining authority
should not be like that, but at the same time,
yes.
Now that the maximum period is there, maximum is there.
Still, it is for the
when
government.
A maximum is, see, that is confirmed while confirming it. While confirming it. But the question is, in confirmation orders also, now many a times this is not finding a place. Does it mean that it is less than the maximum or the maximum? So the question is whether the non-mentioning of the period of detention in the period of detention would vitiate the order of detention. Of course, that is now no longer a syntagram. In T. Devagi versus government of Tamil Nadu and others, reported in 1990 to SEC 456.
19?
The Apex got held.
What is citation, please?
The T. Devagi,
Yes, citation.
T. Devagi
Yes.
versus Government of Tamil Nadu and others. 1990 to SEC 456. 456. The episode held that the non-mentioning of the period of detention would not vitiate the order of detention. And thereupon, this question was considered by a full bench of Kerala High Court. That is in Bose versus Bose, B-O-S-E, Bose versus Secretary to Government, 2010 2 KLT 325. There, relying on the decision of the Apex Court in Makhan Singh versus State of Punjab, AR 1952 Supreme Court 27, as also in Devagi's case, it was held that the non-specification of the period of detention in the order of detention or in the order of approval would not vitiate the order of detention. Then a ground which was usually taken to assail an order of detention is that the live link was snapped, owing to the non-explanation of, or rather the non-existence of a proximate nexus between the preventive action and the past activity, based on which action was initiated. Usually this was a ground which was raised. I will repeat it. The live link was snapped owing to the non-existence of proximate nexus between the preventive action and the past activity on which the action was initiated. In that context, I think that the decisions or scanning of the authorities on that subject, on that issue, would reveal that merely because 3 or 4 months or even 5 months had lapsed in between, by itself will not vitiate the order. Every case we will have to consider, and whether there is a satisfactory explanation for the delay, then if it is explained, definitely one cannot interfere with the order on the ground that the live link had snapped. This was actually considered in several decisions by this court. That is in, I will only give the citations because I don't think that we can go through all these decisions because of our positive time. Mr. Padman, I am not audible.
Yes, yes.
You are very much audible, sir. You are audible.
Audible.
Yeah.
So I will only give the citations. In Jimish Jose versus State of Kerala, 2013 1 KSC 49. Then Rahila Nasir versus State of Kerala, 2016 2 KLT 838. And then Vishnuja versus State of Kerala and others, 2018 1 KLC 933. I'll repeat the citations. Jimesh Jose versus State of Kerala, 2013 1 KHC 49. Then Rahila Nasir versus State of Kerala, 2016 2 KLT 838. And Vishnuja versus State of Kerala and others, 2018 1 KHC 933. These were the decisions. Now, virtually all these decisions, the sum and substance of the decisions is this: even though there is some delay, if it is explained, of course, inordinate, unexplained delay would definitely snap the live link, no doubt. But if it is explained, and for that purpose, if the order did not contain that, it is also possible to for the authorities to explain it in the affidavit. And in one decision, the Vice Court also said, in that regard, the court can also call for the records. And if it is evident that the labeling had not actually snapped, and it was actually explained, and therefore it is not an inordinate, unexplained delay, then of course the labeling would not snap. Then with respect to subjective satisfaction, that of course going by the Act or statutorily, it should be the subjective satisfaction of the detaining authority. And the legislature thought it fit that it should not be the satisfaction of the court. It should be the satisfaction, subjective satisfaction of the detaining authority. And therefore, the courts cannot sit as an appellate court while considering this or considering a challenge against a detention order. The episode made it clear you are not an appellate authority, and therefore you cannot consider whether the subjective satisfaction arrived at is correct or not. If materials are there, and if based on that materials, if this was entered into, then no, the court cannot step in. So therefore, while considering this, definitely courts are taking into account the fact that it is not sitting in appeal over it, or it is not an appellate order which is being exercised, and therefore
rather
the examination.
Rather, the adequacy of the material cannot be gone into. Adequacy, sufficiency of the.
No, that is what materials. If materials are there, whether it is sufficient or not is not the question.
Yes.
If materials are there and based on which if that decision was taken, then can we go into that question?
But existence of material can be gone into. Whether material was
Definitely
there or not.
That is what that is exactly what I am saying.
Yes.
If materials, that is why I employ the expression if materials are there. So therefore, the consideration is whether materials are there or not. If materials are there, definitely we cannot then sit in appeal and then appreciate it again to say that they are not sufficient to form the opinion. If materials are there, I think that quite a number of times Justice Ramgopal had considered all these aspects.
Only for a while only. A little.
Anyway, you had occasion to consider such a matter.
Yes, just sure a term, one term. That's
But all along, we were considering this aspect on this question, realizing the scope of our power. This is not an appellate power, and we are only there to see whether because why it is so is, this act, of course, definitely affects personal liberty, but at the same time, this was enacted with a definite purpose. And therefore, if we are going into and considering all these aspects, then of course, it may ultimately defeat the very purpose of the act. So that legislature, of course, in their wisdom, they thought that the subjective satisfaction, the power to arrive at subjective satisfaction should be left to the detaining authority. And then the court should only consider the question, materials are there. Existence of materials, if that is not there, they do not exist, of course, definitely that can be interfered with. Then one another aspect that is under the CAPA. We all know that a minimum number of 3 cases within a period of 7 years must be there. And if 3 cases were taken into consideration, that is the minimum requirement. And if they are taken into account, but ultimately it is found that one among those cases does not declare or disclose sufficient materials for passing an order, then the number will be reduced to 2, in which even the order has to be interfered with. But take a case where this order was passed after taking into account 7 or 8 cases, and thereafter it was found that no grounds exist actually in respect of 2 or 3 cases. Then, if the minimum number is satisfied with the remaining number of cases, then that order need not be interfered with. It was so held by a division bench of the Kerala High Court in Satyavati versus State of Kerala and others. reported in 2014 4 KHC 576. I'll repeat it. Satyavadi versus State of Kerala and others, 2014 4 KHC 576. That was restated by the High Court in several other cases. And now another important question involved, or rather the decision to be noted in this subject is the one in Abdullah Kunyi, K.M. Abdullah Kunyi versus Abdullah Kunyi and B.L. Abdul Qadir. I will repeat it. K.M. Abdullah Kunyi and B.L. Abdul Qadir versus Union of India and others, reported in 1991 1 ACC 476. Now that is virtually to the effect that the appropriate government should wait till the opinion of the central advisory body is received when a representation is received. So normally the view is that when a representation is received, it should be disposed of at the earliest. But at the same time, the Apex Court in K.M. Abdullah Kunyi and B.L. Abdul Qadir held that the appropriate government should wait till the opinion of the central advisory board is received. And again, that was virtually restated or affirmed in another decision by the Apex Court, that is in Ghulam Biswas, it is B-I-S-W-A-S, Ghulam Biswas versus Union of India and another, reported in 2015 16 ACC 177. In Ghulam Biswas case, again the Apex Court held the appropriate authority, or rather the government, and without any distinction, the detaining authority as well, should wait for the opinion of the advisory board. Virtually, it is only the appropriate government should wait for that. And then, subsequently, this position was clarified by the Apex Court in yet another case. That is a latest one on that point is Ankit Ashok Jalan versus Union of India and others. There, virtually the question was
Reported in? Is it reported?
It is the citation. I'll give the citation. That's the judgment dated 4/3/2020 in the citation 2020-0 Supreme. 2020-0 Supreme SC 232. That's the judgment dated 4/3/2020 in WP Criminal 362 of 2019 of the Apex Court. There the question was, when a representation is submitted after the passing of the detention order, the detainee files a representation before the detaining authority also, and then to the government. Whether the government, appropriate government, as also the detaining authority, should wait for the opinion of the advisory board. Going by Abdullah Kunyi as also Ghulam Biswas case, now this point was virtually not actually clarified in the sense, no distinction was made whether both the detaining authority as also the appropriate government should wait. The dictum is that when the matter is, the case of the detainee is pending before the advisory board, a representation which is received shall not be disposed of, and they should wait for that. That was the dictum in Abdullah Kunya as also in Ghulam Vishwas case. Thereafter, that this question came up, because the consideration is that the contention was that the detaining authority need not wait for this, and then the Apex Court considered this and held in Ankit Ashok Jalan's case that appropriate government alone need wait for the opinion of the advisory board. As regards the detaining authority, it should consider the representation independently and to pass orders thereon within a reasonable time, without waiting for the report of the advisory board. So this is a latest decision on that point. Normally, in the light of Abdullah Kunyi and Ghulam Vishwas case, now courts used to interfere with or rather, decline to interfere with the orders passed by detaining authority if a representation is submitted subsequent to the passing of an order by the detaining authority on the ground that it did not dispose of the representation received thereafter. And it was waiting for the opinion of the advisory board. Now that position is very clear.
But that is applicable only in coffee posa, is it not? In Kappa, it doesn't apply.
No, not at all, not at all, not at all.
In Kappa,
That is applicable only.
No question of detaining authority again considering a representation, is it not?
But true, but at the same time, the Apex Court considered it, and also this court. The question is subject, it is even in one
that
case.
May be coffee posa.
A representation was
case.
submitted. Coffee posa, of course, that can be in coffee posa. That is this particular case, Ashok Jalan's case or Ankit Ashok Jalan's case. That is of course from or under that act, under coffee posa, under coffee posa. So normally, in the light of the decision in Abdullah Kunyi as also in Ghulam Vishwas case, one would think that the detaining authority should also wait till it receives the opinion of the advisory board. But now the position has been made very clear that it should not, it should not wait for the opinion, and it should pass orders on the representation, or rather it should dispose it all within a reasonable time without waiting for that. In short, the Apex Court held that the dictum in Abdullah Kunyi, which was affirmed in Ghulam Vishwas, is applicable only to the appropriate government. And whether I could continue, because what exactly is the time?
No, sir. There is no. You can continue, sir. Continue. There is no like Ramkumar sir used to say. There is no rationing on time. We'll complete the subject, sir.
This Ankit Ashok is how many judges?
Okay.
How many judges?
It is by I will give this. It is by 3.
3 judges. Okay.
No, but now that this position is very clear, because Abdullah Kunyi was also by the Apex Court, and subsequently Ghulam Vishwas is also by the Apex Court. Now, after considering this, the Apex Court held, this is the position. And virtually, the Apex Court held that the decision in Abdullah Kunyi's case should be understood in the light of a subsequent decision by another constitutional bench. The other one was a constitutional bench, or in Kamalesh Kumar versus Union of India. Kamalesh Kumar versus Union of India and others. Reported in 1995 for SEC. For 1995 for SEC 51. So the Apex Court held that this position settled in Abdullah Kunyi's case is to be understood in the light of the subsequent decision rendered by another constitutional bench of the Apex Court in Kamlesh Kumar versus Union of India and others. That is 1995 for SEC 51. Like earlier, I made a mention about the right under 22(5), and I said that it is not a mere right to make a representation, and it also virtually mandates the authority which is receiving it to apply its mind and to consider it. Then, going by the provisions, a contention was raised. That is a proper consideration, is not actually a fundamental right, but that was also settled by the Apex Court. What exactly is the obligation under Article 22(5)? That was considered by the Apex Court as early as in 1989 Supreme Court 1861. In Rema Dontu Borade, RAMADHODU, Rama Dondu Borade, BORADE, versus V.K. Saraf, Commissioner of Police and others. AR 1989 Supreme Court, 1861. Apex Court held that the detainee has a independent constitutional right to make his representation under Article 22(5). Correspondingly, there is a constitutional mandate commanding the concerned authority to whom the detainee forwards his representation to consider the representation within a reasonable dispatch and dispose of the same expeditiously, of course, by applying its mind. Sense of urgency should also be there. That means without any delay, it should be. The Apex Court held that such a representation should be expeditiously considered, disposed of with due promptitude and diligence, and with a sense of urgency, without avoidable delay. Then another question, or this was again considered in a different perspective, that is in Ram Shukriya Hatre, Ram Shukriya Hatre, RAMSUKRYA, MHATRA versus RD Tyagi, AR 1994 AC 1134. The Apex Court held that the right to representation under Article 22(5) of the Constitution includes the right to expeditious disposal, not only by the state government under the relevant provision in the statute, but also by the state central government. So that means if a representation is submitted by a detainee, then that representation should be expeditiously disposed of, and that duty is there, that obligation is there not only with the central government or with the state government, it is also there with the central government. That was in R.D. Tyagi's case. And then, in such circumstances, if there is a delay, because going by these two decisions, it should be disposed of expeditiously. And if there is a delay, and if it's inordinate and unexplained, definitely it would vitiate the order. And in other words, we can say the authority should explain, or they are under an obligation to explain the delay, either by filing an affidavit by the officer concerned on behalf of the appropriate government, or by producing the records dealing with the case. So for explaining that, in R.D. Tyagi's case, the apex court virtually called for the records. And if the files are called for, and if they disclose an explanation for the delay, then of course the order would not be vitiated. So these are the decisions on that aspect. Then another decision which may be very relevant as far as the state law is concerned, or even in respect of central laws. A division bench of Kerala High Court in Tejas versus Inspector General of Police, Kannur. Tejas versus Inspector General of Police, Kannur. Reported in 2015, 3 KLT 1. Considered the distinction between the purpose of an order under Section 3 of CAPA and an order passed under Section 107 of the Code of Criminal Procedure. I think that is also a relevant decision while dealing with these cases. In Tejas' case, the division bench considered the distinction between the purpose of an order of detention passed under Section 3 of CAPA and an order passed under Section 107 CRPC. It was held that under CAPA, the thrust is on prevention of antisocial activities, and under Section 107 CRPC, the thrust is to keep peace and tranquility and avoid breach of peace or disturbance of public tranquility. Therefore, of course, one can also say that if merely because the factum of execution of a bond to keep peace under Section 107, and if thereafter, merely because of that or for some time he had not indulged in any activity, that by itself is not a ground. Definitely, because the cumulative effect of his past conduct and the one which was based, which is the foundation for passing an order under CAPA, if that is taken together, essentially this is a jurisdiction of a suspicion. And if that is, on such consideration is found that the proceedings under 107 is not sufficient to prevent him from committing or rather indulging in activities, then of course it can pass. But application of bind is also necessary in that case. Whether under section, he has executed a bond under 107, whether that is sufficient or not, that is a matter also to be considered. So merely because it is such a bond is executed by itself is not a reason, because we are passing such an order or any order under the Preventive Detention Law, taking into account the past act. There we will have to take into consideration one thing, that is a provision under CAPA Section 3.1 and also the provision under Section 7. I will Section 3 and Section 13. Section 3 and 3.1 and 13. Because 13.1 clause 1 is relevant. That is after the if it's involved in an offense.
Audio breaking.
Sound is breaking. Sound is breaking.
Yeah?
So can you just repeat that? Sound was breaking.
Oh. The relevant provision, or rather, I want you to refer to the provisions under Section 3 and also Section 13 of a CAPA. Sections 3 and 13. why I am drawing attention to these provisions is, if a person who was arrested and detained under CAPA, and sometimes by revocation or expiry of the duration of the detention order, definitely he will be released. But thereafter, after his release, if he again involved in an offense of the nature described in section 2O or 2P, at least in one instance, that is after the release, at least in one instance, then he can again be arrested and detained. Under 3.1, for that, the minimum number is 3. Taking into account the combination of 3 or more, at the first instance, he was arrested and an order of detention was passed and it was executed. Thereafter, even if it is revoked or the period is expired, on its release, if he again commits an offense of the nature described in section 2 or 2P, at least for one instance, that is thereafter, commission of offense for one instance will definitely make him liable again to be detained. In such circumstances, his past conduct, which ultimately culminated in an earlier order of detention, would revive and it can also be taken into account. Then definitely, merely because at that point of time, taking into account the earlier offenses, subjective satisfaction was arrived at, is no reason for not forming subjective satisfaction subsequently, taking into account the earlier offenses and also the last one which ultimately led to the initiation of other proceedings. This is evident from the provisions under section 13. I am gone out or audible?
Sir, audible, sir. Audible.
Though not visible.
Both visible. The video is bit getting stuck, but still it's okay, sir.
And now, of course, we know that whenever an order is passed, preventive detention order is passed, we are actually interfering with the personal liberty of a person. In the light of the fact that the constitutional makers give constitutional sanctity to preventive detention under 22(3), and if the procedures for that are complied with, one cannot say that it is illegal. And at the same time, the legality of an order of detention can be looked into by looking into the various provisions under the relevant detention law. And also, as I said earlier, by looking into the question whether for arriving at the subjective satisfaction for passing an order to prevent him from committing further antisocial activities, the question is whether materials were there. So absence or otherwise of the materials is definitely a point to be looked into, and depending upon the answer to that, the fate of an order of detention would. And one point which I really wanted to make it, to give some stress is, under our laws, that is Article 22(3). It's not actually 22(3). If we are looking into 4 to 7, we can see that that specifically under 22(5). 22(5), I will simply read it out. When a person is detained in pursuance of an order made under any law providing for preventive detention, the authority making the order as soon as may communicate to such ground on which the order has been made. and shall afford him the earliest opportunity of making a representation. The words as soon as, that is giving some concern, because you are preventing the personal liberty of a person, and at the same time 22(5) says the authority making the order shall as soon as may communicate to such person, not forthwith or at the time of arrest. It is not at the time of arrest, but as soon as. It is a matter which is having, or we will have to show some concern. Why? Because I have earlier referred to an international covenant, that is the ICCPR. It contained an article 9.2. Earlier I referred to 9.1 and said that under 9.1, of course, the preventive detention is not actually prohibited under ICCPR also. But at the same time, one will have to take note of one fact. Under ICCPR, there is one another article which enables, rather Article 5 therein, that provides a right to compensation for unlawful detention. That is there under ICCPR. Under Article 9.5, there is a right for compensation for unlawful detention. But no such provisions are here. Of course, under what provision we can go for that. Anyway, no specific provision in any of these enactments, unlike Article 9.5 in ICCPR. But Article 9.2, that is very relevant. That is why I drew your attention to 22.5. 22.5, the words as soon as may be. Whereas in Article 9.2 of ICCPR, it provides A therein. That is 9.2A. Anyone who is arrested shall be informed at the time of arrest of the reasons for his arrest. It makes a difference. When you are arresting a person, the ICCPR says, at the time of arrest, let him know for what purpose he is arrested. This is only a food for thought, but the position is under Article 22.5. Of course, I don't think that I am commenting upon anything. I am only giving a food for thought, because under 22.5, as soon as maybe is the provision, and then under 9.2 of ICCPR, the moment you are arresting, you should let him know for what purpose or what are the grounds for his arrest. I think that since pause here time, I should conclude this, and yes, thank you for giving me this opportunity.
So it was a wonderful.
I think that before leaving, before leaving this, I should give some food for that. That is why I made this comparison. Under Constitution 22.5, it is only as soon as, but ICCPR, the International Covenant, it is at the time of arrest. Please think about it and make deliberations. Thank you.
Sir, it was in fact in a capsule form within the limited time. Wonderful, sir. Ramkumar, sir, your comments on that.
See, I have noticed one contradiction in section 13.2. Please look into section 13.2. The revocation or expiry of a detention order.
Kappa, sir.
Yes, section 13.2. Yes. The revocation or expiry of a detention order shall not be a bar for the issuance of another detention order under section 3 against the same person if he continues to be a person falling within the definition of non-rowdy or non-gunda as given in section 2O or section 2P, and if after release he is found to have again involved in an offence of the nature described in section 2O or 2P, or at least one instance. Now, see, revocation under the kappa, the revocation can be either suo moto under section 13.1. The government can revoke the detention order at any time. Then there is a revocation. Anytime. Then under section 10.4, there is a revocation, mandatory revocation. When the advisory board sends a report to the effect that there is no sufficient ground for then the revocation is mandatory. Government shall revoke because
no option.
In that case,
he has to be
In
released.
that case, will he be a known gunda or known rowdy? He will not be a known gunda or known rowdy.
No doubt, no doubt.
Then in that case,
Then we will have to
how can we say that if such a person who has been found to be not a known gunda or a known rowdy, if he indulges in one case, he can be preventively detained.
Then my answer to
See,
that, sir, my answer to that
before
is,
that, this
yes, sorry.
this-
Yes, sir, please go on.
this problem was reconciled by a harmonious construction of section 13.2 and section 10.4 by a division bench in Prasida versus State of Kerala. But unfortunately, that decision was overruled by a full bench of the Kerala High Court. With the result, we are again back to the same.
No, sir, my answer to this,
Yes.
so if we, I am drawing sir, your attention to 13.2, and
Yes.
if you are reading it
Yes.
carefully,
Yes.
then one thing,
Yes.
the last limb of 22 or 13.2,
Yes.
that is, if he continues to be a person
Ah.
falling within the definition of non-rowdy or non-gunda.
If he continues, means he should have
Then-
been. That presupposes that he is a gunda, known gunda or known rowdy.
What I am trying to say is,
Yes.
if taking into account the materials, if the advisory board says there is no sufficient materials,
Yes.
therefore, based on those materials, based on those cases, materials
Yes.
of course relating to those cases, if they formed an opinion that no, they are not sufficient, then how can that person continue to be a gunda?
Exactly. That is precisely what I am asking.
He cannot.
He cannot.
And therefore, the 13.2.1 would apply only if he continues to be a non-gunda or non-rowdy. And
That is earlier detention order was confirmed.
True.
Only in a case
But at
where
the same-
earlier detention order was confirmed. But that is precisely what Prasida held. Prasida, by making an harmonious construction, tried to save this patent incongruity by saying that the 13.2 will apply only in a case where earlier detention order was confirmed, consequent on the report of the advisory board that he is a known gunda or known rowdy, and government confirms does not revoke. But in a case where if it is revoked, then he is not a known rowdy or a known gunda. In which case, how can you say that he continues to be a known gunda or known rowdy?
Then
That
see
is
the
precisely-
fact that
Prasida was unfortunately overruled by a full bench.
therefore we cannot now rely upon that.
So we are back to the same.
Unless it is doubted
We are back
again
to the.
and, no.
We are back to the same incongruity,
That is
statutory
still-
incongruity.
No, that
Yes,
can
that
be
is only
interpreted only in this way, that is. No, revocation can be on many grounds. Revocation. Suppose if it is revoked
Yes,
on a technical ground,
yes,
and at the same time, without making any specific observation with respect to the materials of the available
that is precisely.
for forming an
That is
opinion,
precisely.
for forming an
So that
opinion.
revocation can only be under
Yes.
13.1, not under 10.4. 10.4 revocation can only be on the footing that he is not a known gunda or known rowdy. In which case there cannot be a further
Then
detention
non-gunda.
under 13.2. That was the interpretation
Therefore,
given in
see, even
Prasida.
without any decision. Now, one thing, instead of relying on that, no, we can definitely consider such aspects simply by looking into 13.2. The question of applying 13.1 would arise only if that particular person continues to be a non-rowdy or a non-gunda.
Continues.
And thereafter, if
Continues.
continues.
That
So we
means
have to give
he must
stress
have
to that
been
word
he must have been a
continue.
known gunda or known rowdy in the past.
But
when
the question
the-
is whether
when
he still continues.
When the detention order has been revoked on the ground that he is not a known gunda or known rowdy, how can we say that he continues to be known gunda? That
you go against,
incongruity,
that very decision.
that incongruity was removed
But
by
we looked into it.
that incongruity was removed by a division bench by harmonious construction in Prasida's case. Unfortunately, Prasida has been overruled on some other point. So we are back to the statutory.
Since it is overruled, I don't think that I will be justified in making any comment upon that in this forum.
Sir, Justice
But at the
Nagapu
same
is
time,
very much present. We can ask him to unmute and join us. Sir, Justice Nagamuthu, sir, can you just unmute and join the discussion?
Oh, yes.
Yes, sir.
Yes,
Your,
yes, yes.
video
Yes,
is
yes.
also off. Would you please on that?
No.
So we have the privilege of seeing you.
Okay, okay. So, good evening to all of our
Good
friends.
evening, sir. Good evening.
Yes, yes. Brother Ravikumar. So, I can't call you no more as my brother
Yes.
Ravikumar, my lord Ravikumar.
Good evening, sir. Good evening, sir. I started by referring your name. I said that no, I should be very cautious when I am speaking of this kind of a subject.
Oh.
When before Justice Ramkumar and Justice Nagapu. I said it at the first instance, sir.
Absolutely correct.
Brother,
That is why I am
really
very cautious when I am saying it.
We are really privileged to hear you today. We are really privileged to hear you today. And your lecture was really wonderful.
Thank you, sir.
And you have touched upon all important legal issues, more particularly constitutional issues. And we are really very grateful. It was a treat for us. And more particularly, Honorable Justice Ramkumar. And he has raised one issue regarding, sir, you have raised one issue regarding the procedures case, another one.
Yes.
So I am not very familiar with both the judgments. May I know whether whether this particular issue was considered by the full bench and overruled, or in general for on other issues it was overruled?
I think so. I don't remember it now, but anyway, this issue was also in the contemplation of the full bench, which overruled Prasida.
Is there any possibility for us to say that the full bench has only partially overruled?
No.
And not this issue?
No.
I do not know about it.
In fact, Prasida, the only issue considered was this.
Okay. This only issue was ruled.
Yeah, this was the only issue. How to reconcile between 13.2 and section 10.4. Revocation can be under two heads. One under the mandatory revocation, consequent on the report of the advisory board. And subsequent, the other one is 13.1 revocation, which is purely within the sweet will and discretion of the government. Such a revocation may not prevent a further detention order, but a revocation under section 10.4 will definitely prevent a further detention under section 13.1 on the happening or 13.2 on the happening of one solitary incident.
Though I am not very familiar with this act and the judgments, the way in which you have put it to me, put it to our participants, I think that I should fall in line with your view.
Thank you.
You are very persuasive. You are also very persuasive.
Food for thought.
Yes. So one more thing, brother. This is, as an outsider, I want to know only one factual aspect. And brother, Honorable Justice Ravikumar, you may also
Yes, sir.
join.
Please, sir.
See, here in Tamil Nadu, we have got one act as known as Act 14, where similar orders of detention are passed. More or less the provisions are more or less the same. So, because quickly I went through this kappa, and I know as to what are the provisions in this Tamil Nadu Act, under which thousands and thousands of people are detained every year. Yes. So what happens in all matters, what is actually practically happening in Tamil Nadu, I want to tell you. The moment a person is detained and he will send a representation and will go to the government and the minister will keep it pending. He will be busy and ultimately he will pass on some order rejecting after some days. So they will immediately file petition under Article 226 before High Court.
Yes.
So only one question we would ask: how many days delay? Is there any explanation? They will say 5 days. In Rekha's case, Hon'ble Supreme Court case has said that even 4 days delay is very material. So they will say 5 days, quashed. Like that, we used to quash. Hundreds and hundreds of matters are quashed in this way, but they do not rectify it. So may I know as to what is the position in Kerala?
Now, fortunately, as Justice Ravikumar said, this Ambit Ashoka case is a welcome decision because the government need not, government should
detaining authority.
Rekha's case, the Supreme Court says 4 days.
Detaining authority, the government need not, should wait for the report of the advisory board. Until then, it need not dispose of the representative. That's a welcome change.
Correct.
on the judicial side, so that
but at the same time,
the government, so that the government will not be blamed for not disposing of the representation within a reasonable time.
Correct. So what is the reasonable time the Hon'ble Supreme
Anyway,
Court has said?
I have not read this decision. I got it only from.
Reka's case is a great weapon in the hands of the lawyers. 4 days delay.
Yes.
Hon'ble Supreme Court is one of the cases says 4 days delay remains unexplained quash.
Now,
So we will ask one thing. We will take at least 25 to 30 cases a day we would list. No, the prosecutor will say these are the cases where there is more than 5 days delay, 6 days delay, like that. He will say any explanation, no explanation, cost.
Yes. Oh.
So in the meanwhile, the person would suffer imprisonment for 6 months. The total period of detention here is 1 year.
Yes.
So without any judicial intervention, because of the delay caused by us, we blame the government for not having considered representation on time. But we keep these petitions pending for 6 months, 7 months, and 8 months. Then we say that we are quashing because the detention order is not legal.
We are not answerable for the delay, for our delay.
Yes.
No, sir.
May you know what is the position in Kerala?
Same thing.
On the question of yes. Please go on, sir. Please go on.
Please,
Mr. Sir, you can go.
No, it's all right.
No, you please, Mr. Hon'ble Justice Ravikumar, you can go ahead.
Yes, you are the speaker today.
Yes.
See, now I want to, in the light of what was put by Justice Ramkumar, that is in the light of Prasida's case. No, Prasida case, that was Prasida versus State of Kerala and others. That was reported in 2009 4 KSC.
9. Yes.
2009 4 KSC 382.
Yes.
2009 4 KSC 382.
But that is the
in that context, overruled decision. Division bench decision.
Yes. Full bench overruled it.
No. True. Sir, you said it. Now, I said in that context, another order, another judgment, that is 2015 2 KLT 134.
Yes.
Not exactly this one, but it is having some relevance with respect to this.
2 KLT, volume 2.
2015 2 KLT 134. 2 KLT, sir. 2015 2 KLT 134.
Yes.
There, I will only see that what exactly is the detail laid on therein. There is no distinction or difference between quality of revocation order passed under section 10(4) and 13(1) of the Act. This is what it said. Whether it is having some relevance, we will have to consider. It says that there is no distinction or difference between the quality of revocation order passed under section 10(4) and 13(1) of the Act. Then definitely, of course, it's a matter to be looked into whether on what ground the full bench reversed the Prasida. That's a matter to be looked into.
Yes.
But in Prasida, now virtually the dictum was that when an order of revocation is passed under 13, the powers under section 3 can be invoked only if the requirements under 13(2) are also satisfied. Exactly. That was the dictum therein. And
he continues to be a non-gunda or non-rowdy.
No doubt,
which means,
because 13.
Which means the earlier order should have been confirmed.
Very correct,
otherwise,
sir,
he is not a non-gunda.
Statutory condition is also there. Statutory requirement is also there.
For want of 3 cases,
yes,
he was found to be not a non-gunda or non-rowdy. In which case, how can we say that he continues to be non-gunda or non-rowdy? That is my doubt. In fact, that was all harmoniously construed in Prasida's case. Let us see.
So definitely the facts involved in one case and on what ground revocation order was passed, all those aspects have to be delved into to consider whether he continues to be a non-gunda or a non-rowdy. But anyway, in the light of 13(2), there can be no doubt at all. 13(2)(1) can be invoked only if that particular person who was detained and then released continues to be a non-rowdy or good. Otherwise, there is no application. There can be no application at all. That is very clear.
The release can be either due to the expiry of the entire term or due to the intervention of the advisory board.
Yes.
Yes, 13(1) or due to the intervention of the
32 itself starts like this. Sir, the revocation or expiry of a detention order.
Exactly, yes.
That will not be a bar. Then provided the person continues to be a rowdy or non-rowdy or non-gunda.
It could have been made clear that the revocation under section 13(1) will not be a bar. Then things would have been better. But revocation, it only says revocation. It can include a revocation under 10(4) also.
Without making, that is why, sir, that is why I refer to the other decision.
Yes.
That is,
no distinction.
There is no quality difference in quality in 10(4) and 13(1).
Maybe the consequence of revocation, no quality. But in one case it is mandatory. In another case it is optional.
See, I refer to that decision because sometimes there may be scope for further consideration on that aspect. That is why I readily, that is why, sir, I
have not read that decision.
And that is why, sir, when you said about this, I really refer to this decision only to say that going by the decision, there is no quality, there is no distinction between these two. But of course, regarding the impact, there cannot be any doubt at all. There is no room for any doubt at all.
Yes.
In 10(4), if the advisory board is of the view that there is no sufficient materials, then there is absolutely no question of detaining that person any further. He has to be released. Then, when the board says that there is no material, how can in a subsequent case, or rather, if the same person commits another offense, how can any other the detaining authority say that the materials which were considered and the advisory board arrived at a conclusion that those materials are not sufficient? How can the detaining authority again say that no, those materials are sufficient? Because going by, yes, sir.
That is
because going by 13(4),
yes, please.
And therefore, no 13, going by 13, then see on commission of one more offense, the earlier one it will automatically get revived, and or that would become available for consideration.
Yes.
Then not only for consideration, the question is, it was held that at that point of time also, subjective satisfaction is to be arrived at not with respect to that subsequent and lastly committed offense. It should be arrived at based on the earlier also. You cannot say that earlier we had arrived at a subjective satisfaction. If 3 cases were taken earlier, and then on commission of one more offense after release, the detaining authority has to arrive at a subjective satisfaction taking into account all the 4, not with respect to the, or it cannot be confined to the last one, going by the provisions. Then, as I said, a view taken by the, or rather an opinion formed by the advisory board may be resulted in revocation, and then ultimately, sometimes a situation may arise where, contrary to the opinion, the detaining authority again will form an opinion saying that they are sufficient. Otherwise, how can he pass an order based on 13(2)(1)? Then a incongruity will be there, because materials were actually considered, then advisory board found that they are not sufficient. That is unquestionable, because the only option in such circumstances is to let the man free. How can those materials again be appreciated? Question to be
section is not happily worded. 13(2), not happily worded at all.
As you rightly said, sir, it did not say that a revocation under 13(1).
Yes.
So when merely the word revocation alone is used, definitely when revocation is also possible under 10(4).
10(4).
We cannot say that it is only meant the revocation under 13(1) alone. We cannot say.
Yes, and 10(4) revocation can be on the ground that he is not a non-gunda or non-rowdy. In which case, how can you say that he continues to be a non-gunda or non-rowdy within the meaning of 13(2)? Anyway,
rather 10(4), the advisory board is only looking into the sufficiency or otherwise of an opinion. They are only giving that, whether it is sufficient or not. If we are reading 10(4), it is like this. in every case where the advisory board has reported that there is, in its opinion, sufficient cause for the person for the detention of a person, then of course the option is there with the government. But when the advisory board has reported that there is, in its opinion, no sufficient cause for the detention of a person concerned, government shall revoke.
Yes.
So once, based on the materials, the advisory board formed an opinion that no sufficient cause for detention, then there is no option, government should revoke it. How can the same materials be again relied on?
Exactly.
That's the point. I think that, sir, I think that you are actually on that point.
Yes, exactly. Anyway, that will have to be considered by a larger brain probably.
Definitely, at that point of time, definitely the question is how the word revocation employed in 13.2 should be understood. Whether it should be taken as revocation under 13.1 or will it taken only, or will it taken under 10.4 as well?
Exactly.
That's the point to be. I think that's a matter to be. Thank you, sir, for enlightening me on that aspect.
Before we move on to the interactive session, Nagamuthu sir, would you like to add on something onto that, or can we go to the interactive session? I think Nagamuthu sir has muted himself again. Sir, a couple of questions have come up. Ravikumar sir, couple of questions have come up. The quintessence of this is something like this, sir. That is, this is a draconian or a harsh law wherein the life, liberty, etc. of an individual who is not even accused or committed of an offense is put on stake, and the constitutional validity of which has been upheld by the Supreme Court, and judicial intervention by even viewing it as not an appellate body, it's not an appeal, or we cannot have much, it's a minimal interference on the part of the judiciary. In these cases, if this act is misused, the common doubt is that, is there any occasion when persons could sue the government or the authority for unnecessarily detaining him and get any compensation?
Shyampadman, I think that you must have noticed, now before parting with this lecture, I drew our attention of all that there is one specific provision under Article 9.5 of ICCPR. I did not make any comment upon that. Correct. I said that if it is an unlawful detention, the person can go for compensation. But there is no specific provision here, but still there is a matter to be probed into. But one thing, we cannot simply say that this is not at all required, because if a particular person is becoming a menace to the society, how can we let that particular person to do things according to his will? So there must be some provision. The question is, that is why time and again the Apex Court as also the High Courts, various High Courts held. Existence of power is one thing and exercise of power is a different thing. Correct. I think that we will have to bear in mind this particular thing. Existence of power, that is one thing, and exercise of power. You will have to apply your mind, find out whether this is a befitting case where we should exercise the power. The power is with you, but whether you should exercise this. If you are unnecessarily, unwarrantedly exercising that power without any basis, bereft of any basis, then I will put that big question mark there.
So there again, one issue also comes in. Power corrupts, absolute power corrupts absolutely. So if you give unbridled power and minimal intervention by the checks and balances, then again you are exposing the citizens to great peril.
That is why courts are very, very strict in considering an order of detention order. If some violation somewhere, that is enough for ordering release because of Article 21, procedure established by law. If there is some lapse in the procedure, courts are very strict.
See, that was available to the courts only because of Maneka Gandhi's case.
Yes.
Because earlier, under A.K. Gopalan's case, it was not there. That is why I said the other one virtually, I only employ the expression virtually overruled in the sense that the expansive interpretation was given to Article 21 in Maneka Gandhi's case. But for that, yes, this would not have been possible.
Sir,
and I think that one more thing. So, one thing, that is the South Asia Human Rights Documentation Center. South Asia Human Rights Documentation Center. The acronym is SAHRDC. It's very difficult to say South Asia Human Rights Documentation Center. Use the acronym SAHRDC. It makes certain recommendations. And one among them is the one which I earlier said, that is regarding 9.2, extensions of Article 9.2 in ICCPR.
Compensation.
At the time of arrest, no, the other one, sir. At the time of arrest itself, one should be told what exactly the grounds for arrest.
Grounds.
Whereas 22.5, it says, as soon as maybe.
Yes. And CAPA is 5 days. CAPA gives 5 days.
Yes. I did not make any mention about all those things, sir. But at the same time, sir, you know, when a person is arrested, at least at the going by this Article 9, then and there you will have to say why we are arresting you. But here, no, that is not there. No, they can definitely wait for that 5 days, because they need to divulge the fact only within 5 days, whether everything is necessary or not.
Sir,
that is why I said, I think that the value of any discussion should be, if ultimately after the culmination of the discussion, if you are not giving anything for, or rather a food for thought,
correct,
then it will be a futile one. I think that I gave something, some food for thought. Thank you.
Sir, may I just, a couple of persons would like to get some clarifications. 2 hands have come up. One is Mr. Murthy from Hyderabad. Radhakrishna Murthy. You will have to unmute yourself.
Yeah, my question is actually, see, under Article 2, is there any time limit for supply of, these grounds?
As early as possible.
Grounds of detention.
As early as possible. As
early as possible. Actually, is there any fixed timeline?
No.
But under certain acts, it is there.
Grounds of detention should
as
be
soon as may. Constitution is as soon as may be.
Constitution, it is only as soon as. That is why I said, in Constitution 22.5, it only says that as soon as.
As soon as may be, yes.
So as soon as maybe means once, see, today that they have given certain grounds and all, okay, and that they have detained.
Yes.
After 4 months, can they add some more grounds? Will it become the?
I don't think that is possible, because in the case of
that will be compliance of 22.5 or not article, because
no,
once it is after a few months.
Sir, Mr. Murthy, one thing. No, I did not disclose. I did not exactly remembering the citation, but the citation is with me. That is why in one of the cases the Appeals Court itself said, no, that was a case where an authority was actually empowered to consider a particular matter, touching the right of another. The application which is claiming that right was denied, or rather rejected, citing one reason. Again, he submitted another one, and at that point of time, it was rejected on another reason. Then the Appeals Court held, when you are rejecting anything or any representation touching the rights of a person, all grounds which are available, that should be reflected in the first order itself. You cannot say one ground at one point of time, you cannot say another ground at another point of time, and yet another ground at another time. You will have to, the authority has to say, what are the grounds based on which we are rejecting it. I think that if you contact me later, I will definitely give the citation also. Because no, this is not a matter which I should, I expected that question. But definitely a very good question, I should say. That was a very good question. But it is not a position which is totally grey, or rather a grey area. The Appeals Court held, reasons should be disclosed.
Yes.
At the first instance itself. Otherwise, it is nothing. One can say it is nothing but a hindsight. For the purpose of rejecting it, if that authority is destined to reject it, then he can say one reason, one point of time. again he comes up with another petition, he can again reject it by citing another reason. That should not happen. That is why the appeals court held. If you are rejecting it, disclose the reasons at the first instance itself. It's not possible for you to say or find out. Rather, the word which was, I do recollect one thing, the word employed by the Honorable Appeals Court was that you cannot fish out reasons.
Not supposed
That
to
was
add
the
it.
exact expression which was used by you. You cannot fish out. So that means fishing out reason for the purpose of rejecting it. That is not possible. The Appeals Court held.
Thank you, sir. Then we have Advocate.
I think that one more thing, Mr. Padman. I will give you the citation to Mr. Padman. You can collect it from him.
Definitely, I shall circulate.
I will give that
Krishnamurthy, I will circulate it. Okay.
Thank you.
You get that, sir. It is there.
Okay. Now we have got Daya Sindhu.
I am sure about it. I am sure about it because
yes.
now sitting along with our present Chief Justice, Justice Manikumar, we
Correct.
dealt with this question. That is in respect of a university. The application was rejected by the university once. Again, the application was submitted after curing certain defects. This time it was rejected, citing another reason. Then we quoted this decision and said that you cannot fish out reasons. A very recent decision.
I think Sharath wants to add something. Sharath,
yes. Yes, sir. Yes, sir. Sir, coming back to 13.1 and 13.2 again.
Yes.
The determination of section 13.1 that a person is not a gunda, that puts a full stop
Yes.
to insofar as his allegations against him are concerned. Now, when coming to 13.2, 13.2 does not say subject to what 13.1 says or order what. It goes without saying if a person has not been decided by the authority that he is not a gunda, 13.1 puts an end to his entire agony. 13.2 comes into picture only if he still on other grounds he is released. So the 13.2, as we have already discussed, sir, Justice Ramkumar sir also said,
Yes, sir.
13.2 is not happily worded. Should not, are we concluding with a question mark? Why 13.2 is not properly worded? Is 13.2 13.1 should have also included subject to what 13.1 says? Is my doubt, sir.
See, as rightly said by Justice Ramkumar, no, it would have been suffice if in 13.2 it is made specifically clear that revocation under 13.1.
Yes, sir.
Because the incongruity occurred only because there is yet another power in the very statute itself for revocation under 10.4. 10.4. So therefore, without making any distinction between the revocation under 13.1 and 13.4 or 13.1 and 10.4, when you are employing the simple expression revocation, then this incongruity will come. That is why I brought to the attention the decision in Radhika, where it says that there is no distinction. So then the consideration would be very, very, very difficult, because in the light of Radhika, again, we will have to consider whether there is any distinction between the revocation under 10.4 and the distinction under 13.1. The decision says there is no distinction. If there is no distinction, then in 13.2, you need not make any or specifically say that it is either under 13.1 or 10.4. If there is no distinction, there is absolutely no necessity to say. I am only saying that if there is no distinction, then there is no necessity to make any amendment to this 13.2 by clarifying by the word revocation. We actually meant revocation under 13.1 or revocation under 10.4. But if there is any difference between these two, necessarily you will have to say, in which one, definitely one can only presume that the word distinction denotes revocation under 13.1. If there is a difference between these two.
Thank you so much, sir.
correct, sir. Now we have Nawaz.
Thank you for that question.
Sharath, thank you very much. A long time we have not met.
Yes, sir. Hello, sir.
Now we have got a question by Nawaz Jan, please.
Yes. Good evening, sir.
Yes, please.
First of all, thank you very much for such an insightful session, giving the latest updates by incorporating the latest updates. Now, I have got two questions. One is, have we been able to draw a line of justice between the human rights violation and the preventive detention? My second question is, since these provisions are prone to arbitration, arbitrariness and dilution, the advisory board, which relies on the material before it, while taking a decision with regard to the extension of the period of detention, whether the advisory board relies on the material provided by the authorities alone, or whether there is an opportunity for the detainee also to represent, or based on these two, representation by the detainee and the material provided by the authority, the advisory body is taking a decision whether the period of detention is to be continued beyond 3 months or not. These are my questions, my lord.
Now, one thing. Now, I want a clarification on the second question.
Yes.
You said when it is extension.
Beyond initially.
No. What exactly you meant by using that word?
Extension in the sense that the period of detention, maximum period of detention as given in the constitution is 3 months. 3 months. So, if the period of detention is required to be extended, or in other words, if the authority wants the detainee to be continued in detention, it has to be done only on the advice of the recommendation of the advisory board. Beyond 3 months detention, cases which require
3 months. Now that 3
yes.
months is virtually there in Article 22.4.
Yes.
22.4 you might have noticed. No law providing for detention shall authorize detention of a person for a longer period than 3 months unless. Therefore, for 3 months, the matter need not go before the advisory board. Going by Article 22.4, it says, no law providing for detention shall authorize the detention of a person for a longer period than 3 months unless an advisory board consisting of persons who are or have been, then the qualification.
Yes.
Before the expiration, it is only there, the word expiration of the period of 3 months, that there is opinion sufficient for cause for detention is used. Therefore, it means if it is 3 months or less than that, no, the matter need not go before the advisory board.
No.
So that is going by the rule itself. I think the provisions under Article clause 4 of Article 22.
Yes.
If it is not, it is only 3 months or less, matter need not go before the advisory board.
Exactly.
If it is more, definitely it should. Then in CAPA, which the particular statute which we have considered or referred to here and before, there one specific provision is there, which says, that is section 2, which provides for maximum detention. That is the provision.
Yes.
Section 12, maximum period of detention under CAPA. It says, in pursuance of the first detention order made against any person under this Act and confirmed under Section 10, the power of confirmation is under 10. He may be detained for a period which may extend up to 6 months. So, at the first detention order or based on a first order, the detainee after confirmation of that order by the government under Section 10 can be detained only for a period of 6 months. Then 6 months from the date of a detention, and then in pursuance of such a subsequent detention order. That is, if on a second occasion, the very same person against the very same person, another order of detention, that is after the first order, another order of detention is ordered, then he may be detained for a period which may extend up to a maximum of 1 year. 1 year. It is taking into account all these questions that at the very outset also I said, when 12 is the provision, and if in an order or in the order under Section 10 confirming the order, or rather confirming the order, if the period is not mentioned, what is its impact? Relying on or referring to the decisions of the appellate court, I think that definitely I said that it would not vitiate the order of detention. Merely because that was not specifically mentioned in the order of confirmation under 10, that would not vitiate the order of detention. because in such circumstances, it should be taken. Rather, we should presume that the detention is for the maximum period, because in any way, it cannot go beyond 1 year. So that if not mentioned, it should be 1 year. Provided it is the second occasion or the third, and so on and so on. Otherwise, if it is the first detention order, it can only be for a period of 6 months. Thereafter, it can go up to 1 year.
On expiry of 1 year, he has to be released. He shall be released.
But the interesting thing is that hitherto I never come across any order wherein a person is detained above 6 and lesser than 1 year.
No, when eminent political leaders were also detained, keeping in with the public order and other things, in such cases, now my doubt was whether the advisory board relies on the materials provided by the authority alone, or is there if any opportunity is offered to the detainee also?
No. Only on the materials which were available before the detaining authority.
Detaining authority.
Yes.
The body veteran marshal is not there in case.
There cannot be any subsequent material added.
Yes.
No, one thing. No, your doubt. I would like to add one thing. Earlier, I said that some recommendations were actually made, or rather suggestions were made by. Am I audible?
Yes, sir.
Yes.
No, some suggestions were made by the South Asia Human Rights Documentation Center, wherein this was one subject. One of the suggestions. That is, virtually it is their suggestions. In fact,
yes.
Now they say, I will simply read it out. It says that individuals held under preventive detention must be given the right to legal counsel and other basic procedural rights provided in Article 21, 22.1 and 22.2. It says, Article 21 of the Constitution, for example, guarantees the right to legal counsel, but Article 22.3b strips the right from persons arrested or detained under the preventive detention law. Relying on these provisions, then they refer to Akaroa's case. And thereafter, their suggestion is that contrary to India's constitutional practice, UN Human Rights Committee has stated that any person arrested must have immediate access to counsel. Article 22.3b of the Constitution denying detainees virtually all procedural rights during advisory board proceedings must be repealed is their suggestion. It is only a suggestion. That is, denying detainees virtually all procedural rights during advisory board hearings must be repealed is one of the suggestions. But till now, there is no such right available to the advisory, before the advisory.
But advisory board permits lawyers. Advisory board allows lawyers.
They are permitting. I think that, sir, you were there in that committee.
We were permitting lawyers.
Yes.
And not only
you are one of the members.
For preparing the representation also, the jail superintendent is giving them the benefit of a counsel, an advocate of their choice for preparing the representation. Because after all, it may require some legal brain. Therefore, that there also the CAPA Act has provided for that legal representation. Only thing is, at the time of arrest, they don't have. At the time of arrest, they don't get any legal, no right to consult a lawyer or be defended by a lawyer. But at the time of preparing the representation from the prison, while in custody, they are given the right to consult a lawyer. And then at the time when the matter comes up before the advisory board also, they are given, they make a request, and that is invariably allowed by the advisory board.
See, that is why 22.3. Now, to start with, also I drew attention to 22.3, and before that, I drew attention to 22.1 and 2, because 22.1 carries two fundamental rights, or rather, it provides two fundamental rights. One among them is right to be defended by a legal practice of his choice. No person who is arrested shall be detained in custody without being informed. There also the word as soon as may be is there. So 22.5 and 22 in 22 also the words as soon as may be it is there. Of the grounds of arrest, and shall he be denied the right to consult and be defended by a lawyer. So the right to consultation is there under 22.1. That is there. I am only on that. Article 22.1 provides that a person who is arrested should have the right to consult. But at the same time, 22.3 says nothing in clauses 1 and 2 shall apply when any person who is arrested or detained under law providing for preventive detention. So why it is not being granted? It is very much evident. It is not granted because there will not the clauses 1 and 2. The fundamental rights guaranteed under 1 and 2 will not be available if a person is arrested and detained under any law providing for preventive detention. So the provision is very clear. It was not being given because of 22.3.
Correct, sir. So we have Srihari with a question. Srihari, please.
Good evening, Lordships. Lordship, I have a doubt whether the subjective satisfaction is personal satisfaction of the detaining authority or the satisfaction of the office of the detaining authority under COFE Posanal.
Why doubt that? This is subjective and objective. Objective and subjective satisfaction of the detaining authority.
Yes.
There can't be any doubt.
Yes.
And at the same time, now one more thing we will have to take note of. Whenever a discretion is given to one person, the also held that discretion should not be simply personal. It should be taking into account in accordance with the law. So otherwise, it will be arbitrary.
Correct.
Judiciously exercised. Discretion also should be judiciously exercised.
That it should be exercised.
Section 7.3 provides for legal consultation for preparing the representation. 7.3.
But in some acts it is not there.
That is CAPA 7.3 provides for that.
Now that is why I said, sir, due to this positive time, we are not having time to take into account the provisions under each and every act and to say which are the provisions which are specifically there in one act and which should have been there in the other act. But unfortunately, we are not having that.
That's Prem.
Hello, sir.
Yes.
It was really an excellent, informative discourse on this subject, and you really adopted something like a unique approach to the topic. It was a perfect performance, I would say. But so you're most welcome, sir. And I do have a small doubt, sir, regarding that Article 22.5. Article 22.5, it would require that grounds of detention must be communicated to the detainee, right?
Yes.
Now, suppose a detainee is not conversant with English. The grounds of detention, it has been drawn up in English. Anyway, the detaining authority, he says that he has fully explained all those grounds in the language which is known to the detainee. Can you say that it is a way of communication? Is it sufficient? Is it a sufficient communication under 22.5?
No, but at the same time, one will have to consider one aspect. When the order of detention and subsequently the grounds of detention are communicated to the person, if that communication is in a language which is alien to that particular person, necessarily the legal requirement is only to let know the party what exactly are the grounds based on which he is detained. In which event, the communication should be that of the grounds. So he should be told. When he is given the order and he is made to understand what exactly are the grounds, and if that they are translated and made known to him, these are the grounds. Now, how can we say that they will not actually satisfy the requirement? Because even in the case of filing of a wakalat, because if you are Now, filing a wakalat of an illiterate, definitely you will have to make an endorsement that now the contents were read into and translated in his language which is not to him. So therefore, now this is a method which is recognized legally, a legally recognized method. No, otherwise, no, it is, how can we say that, no, because we are arresting a person, you do not know whether he is conversant with English or not. We are not asking that particular person beforehand, whether you are conversant with English or which is the language in which you are conversant with. You are arresting a person and then you are giving it. Then definitely the intention of the provision is that person should not be in darkness with respect to the grounds on which he is arrested, because now that is a legal requirement. No person can be can be virtually.
No, my question was if the grounds are in English and the person says, the officer says that verbally it was explained. No, the grounds, nothing in writing is left with the detainee. It is only saying verbally he has been explained, but this is in English. Because the whole purpose of that particular to communicate means it is to make a purposeful and what you call so that the detainee can make a very purposeful and effective representation.
Yes, very, very correct. Definitely, I think that what you are saying is 22(5) should be a meaningful remedy.
Correct.
Because it is the one and the only guarantee which is given to a detainee.
Correct.
To make a meaningful representation, that is why all these materials, not only the order, the materials are all provided to him to make a meaningful and a substantial representation.
Correct.
Then, if suppose several documents are relied on, and all of them and most of them are in a language which is known to that person, then necessarily it would take some time to translate it in the language which is known to that particular person. In this event, no, though we have earlier said that it should be, the grounds of detention should be given to him forthwith or at the time of arrest, then how it is possible? Then necessarily we will have to say that the expression used by the legislature, as soon as it is correct, then we will have to say, because they think that might have think or thought about this thing, because there may be a situation where that authority will be constrained to translate or certain things, and therefore it would not be possible to give it to him at the time of his arrest, and it may take some time. So then we will have to consider that aspect also, whether that word as soon as should be there, it should continue to be there, or that is why I said, what is the intention? The avowed purpose is to communicate this to that particular person. But one should have to ensure that that is properly communicated to that person.
Correct.
That should be there. The contents, the grounds should be translated to that person so as to enable him to make a meaningful, a purposeful representation. If that is not done, of course, but if that is given to him and then it is translated to him or he was made to understand in his personal language which is not to him, how can one say that that will not satisfy the requirement?
Thank you so much, sir.
May
great talk.
Excuse me, may I add something to this? Actually, this point was already considered by the Supreme Court.
True. I am not oblivious of that.
1981 Supreme Court, they said actually in that case also grounds of detention was in English. Subsequently, orally that they have informed in his mother language. But the court said, Supreme Court said, no, that is not sufficient and all. Therefore, it is not complaints of 22(5). That's what the Supreme Court had.
Then the question is, that is why I said, of course, if it is covered by a gentleman, of course, one cannot say anything. Then the question is, definitely this provision, no, the words as soon as, it should continue to be there in 22(5).
That point, whether that they have considered or not, I am not
We do not know.
I have read the statement 1980 Supreme Court, that is Biryani, I think, BHIRANI. Biryani versus
Radhakrishnamoorthy will look into it.
There one thing. No, we cannot distinguish that decision simply by saying that this point was not considered by the Apex Court, because under Article 141 we are bound by the declaration of law. One cannot say that this angle was not at all looked into. Whether it is looked into or not, once a declaration is made by the Apex Court going by at least two decisions. One is by none other than Justice V.R. Krishnaiyer in Fasulumbi versus Akaroa in 1980 Supreme Court. There the Apex Court, Justice Krishnaiyer held, when a decision of the Apex Court is cited, it is bound before High Courts. It is bound on the High Court not only by way of the rules of precedence, but by virtue of Article 141. On that point, Justice K.T. Thomas also held in one another decision that a decision which is binding cannot be distinguished simply by saying that a particular point was not at all considered. Whether it is considered or not, it is the decision, therefore it is binding under Article 141. And if you are saying that or trying to distinguish it by saying that one important fact was not at all looked into, it is as good as overruling the decision, which cannot be done by any High Court. And therefore, under 141, whatever be the decision of the Honorable Apex Court, that is the decision, that is the law of the land. We are bound to, respectfully, we will have to follow that.
Judicial discipline demands that, sir.
It is not only the discipline. Not only the discipline.
141.
There is absolutely no way, other way. Under 141, you are bound to. Anyone who is dealing with that, is bound by that declaration of law by the Apex Court, and therefore, under Article 141, whether it was considered or not. And then Justice Krishnaiyer said, in such circumstances, of course, the Honorable Apex Court may revisit. Apex Court may revisit, but you are not having that power to revisit. You are simply bound by Article 141, and therefore there is no room for any further discussion on that aspect. When the Apex Court decision is there, one need only to respectfully follow that.
Correct, sir. Sir, that brings us to the end of the 38th session of Legal Empowerment Through Interaction lecture series. It was indeed a wonderful session, sir. We had a lot of interaction, and especially thanks to Justice Ramkumar sir and Nagamuthu sir, there was a lot of interaction on these different aspects. So Justice C.T Ravikumar sir, thank you very much for...
I should also express my gratitude to Justice Ramkumar and Justice Nagamuthu.
Thank you.
So thank you very much, and we are privileged to have so many participants, especially Kumarangutti sir from Calicut, one of the senior lawyers whom we respect a lot. Each and every participant, sir. Thank you very much. Tomorrow we will be meeting at the same time. Tomorrow the faculty is Advocate N. Manoharan. He is an advocate of Madras High Court, suggested by Nagamuthu sir. He will be dealing with the subject, an overview of execution in CPC. And Justice K.T. Shankaran sir has consented to be the moderator tomorrow. So till tomorrow, 3:30, till we meet again, take care, stay safe. Thank you.
Thank you.